Hello and welcome to yet another video on AI Pulse, presented by your mentor, Vivek. If you use an AI note taker in your meetings, and a lot of you do, you probably saw a headline this month about one of them being sued for secretly recording people. The headlines were loud, so I went and read what was actually filed. And the most important fact about this case is one that almost none of the coverage put near the top. Nothing has been decided, not one thing. The company has not even responded on the merits yet. Let me show you what a complaint is and what it is not. First, the facts of the filing itself, which are not in dispute. A document exists, and here is what it says on the cover. The case is Chamberlain versus Granola, filed on the 30th of July, 2026, in the Northern District of California. The plaintiff is Tara Chamberlain. The defendants are Granola Incorporated in Delaware and Granola Labs Limited in the United Kingdom. And it is a proposed class action, proposed being the operative word, because no class has been certified. And the allegation is specific, that the product captures meeting conversations invisibly. No bot joins the call, no notification appears to the other participants, and that those recordings are used to train its own models by default. And the sharpest part of the complaint is that it quotes the company's own marketing, which described that invisibility as a selling point. That is the strongest version of the plaintiff's case, and I wanted you to hear it properly before I complicate it. The complaint brings 7 legal theories. I will not read all 7 at you, but the shape matters. There is the Federal Wiretap Statute, the Electronic Communications Privacy Act. There are 2 separate California Invasion of Privacy Act claims, one for wiretapping and one for recording confidential communications. There is California's Computer Data Access Law, its Unfair Competition Law, Common Law Intrusion upon Seclusion, and Unjust Enrichment. 7 theories, because plaintiffs plead in the alternative. That is normal, and it is not evidence of anything. And here is the status, which is the thing I want you to actually remember. No court has ruled on the merits. The defendant has not responded on the merits. A complaint is one side's account of events written by that side's lawyers before a single piece of evidence has been tested by anybody. It is the beginning of an argument, not the end of one. And now let me do the thing the coverage did not, which is give you the other side. Because on the federal claim, the plaintiff has a real problem. The federal wiretap statute operates on one-party consent. Broadly, if one participant in the conversation has consented to the recording, the interception is generally not unlawful under it. And in this scenario, the person running the note taker is a participant in the meeting, and they plainly consented, they installed the thing. That is a structural difficulty for the federal claim, and it exists before anybody argues about the facts. There is an exception where the interception is made for a criminal or tortious purpose, but commentary on this case notes that the exception faces significant hurdles under how the Ninth Circuit has read it, which is where this case will be heard. So the federal theory is not a slam dunk, but, and this cuts the other way, state law is not the same as federal law. California is an all-party consent state. So the California Invasion of Privacy Act claims do not carry that same one party problem, and they may well be the stronger half of this complaint. And I want to be very clear, I am not a lawyer. This is not legal advice, and I am describing the shape of the arguments, not predicting who wins. So, what should you actually do? And the nice thing is that the answer does not depend on who wins. Four things. 1. Find out which note takers are actually running inside your organization, because it is almost never the list you think it is. 2. Audit the single sign-on and OAuth permissions those tools hold, because that is where the real access lives. 3. Write down a recording policy that accounts for all party consent jurisdictions, since your colleagues are not all in one country. And 4. Read your vendor terms on whether your data trains their model and whether you can actually get it deleted. And the discipline underneath all of this, an allegation is not a finding. It is very easy to read a complaint and feel like you have read a verdict, because complaints are written to be persuasive. Extend the company. The same care you would want extended to yours if somebody filed against you tomorrow and every outlet ran the summary. So here is the verdict. This is a real case, citing real statutes, raising questions that genuinely need answering about tools that sit silently in millions of meetings. It is also, as of today, entirely undecided. Go and fix your own consent settings this week. That part is in your hands, and on the rest, wait for the court. Once more, I am not a lawyer, and this is not legal advice. If you found this useful, please like, share, and subscribe. Thanks for patient listening, and see you in the next video. Until then, peace out.